What are the factors for granting bail? The top court bench, comprising of Justice L. Nageswara Rao and Justice Hemant Gupta, noted that there are factors to be given consideration when giving bail, like the seriousness of the crime committed, the possibility of accused to escape from justice and keep committing the same offence, the possibility of destroying or spoiling the evidence as well as witnesses, and the court granted bail to accused appellants while setting aside the judgment of the High Court. This was in the case Michael Dharmarajam and others etc. versus State of Telangana and another. As per the FIR lodged by the second respondent, it was alleged that deceased husband of the second respondent was a chairman of Fishermen Cooperative Society, Chamanapalli village, and only members were allowed to catch fish from the tanks. Appellants were members, but later their membership got cancelled, which resulted in disallowing them to catch fish from tanks. And 3 years prior to the complaint, the deceased was attacked by the appellants at Panchayat office, whereby that criminal case was pending. And one day, when the deceased went to examine the tank, he was injured by the appellants, due to which he died. FIR was filed under Section 148, Section 120B, Section 302 read with Section 149 of the Indian Penal Code. Accused appellants filed a bail application before the Principal Sessions Judge Karimnagar, where the court granted bail on certain conditions, and so the second respondent filed a petition for cancelling the bail under Section 439 Clause 2 of the Code of Criminal Procedure before the High Court of Telangana, where the court cancelled the bail of the accused appellants. And thus, an appeal was filed by the appellants before the Apex Court, where the court observed. In Raghuveer vs. State of Bihar, this court held that bail can be cancelled where, first point, the accused misuses his liberty by indulging in similar criminal activity. Second, interferes with the course of investigation. Third, attempts to tamper with evidence or witnesses. Fourth, threatens witnesses or indulges in similar activities which would hamper smooth investigation. Fifth, there is likelihood of his fleeing to another country. Sixth, attempts to make himself scarce by going underground or becoming unavailable to the investigation agency. Seventh, attempts to place himself beyond the reach of his surety, etc. The above grounds are illustrative and not exhaustive. It must also be remembered that rejection of bail stands on one footing, but cancellation of bail is a harsh order because it interferes with the liberty of the individual, and hence it must not be lightly resorted to.